Welcome to court, Ms. Guerra. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present by video conference. Are you Ernesto Guerra?
Yes.
Welcome to court, Mr. Guerra. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Ms. Garcia, at the last hearing, I think you or someone on behalf of your office announced that the Attorney General's office was not participating in this legal proceeding. Has anything changed?
No, Your Honor, that's correct. We are not participating in this case. We do have a child support enforcement case pending in master court right now, but we're not going to appear in this case.
Understood. Thank you, Ms. Garcia. Mr. Tames, Ms. Aldana, many motions to consider. What is the announcement?
Your Honor, we have a motion to compel and motion for sanctions that the petitioner filed. And we also have a motion to appoint a real property appraiser. That is what we have pending before the court.
I see the enforcement, compel and sanctions, and appraiser. I see that. Ms. Aldana.
Yes, Your Honor. I filed a motion to reinstate the special appearance of Mr. Ernesto Guerra, and also a motion to reinstate Ms. Naila Guerra's motion to dismiss the case for lack of jurisdiction. So before going into the motion to compel, I would ask that I be heard on the special appearance, which is the reason why we didn't address the motion, the discovery, which is what I expressed to Mr. Dames's office.
Give me 1 second. Let me see if I understand the last part that you said. You said you didn't move on the motions. Why?
Because we are still pending Mr. Guerra's special appearance. So I didn't want to respond to something and wait.
No, I thought you said something about the master, because we were last here, whenever that hearing was, and I think that was set, the special appearance and the motion to dismiss, all these things were set, but then by agreement, I think the parties mutually agreed to a master in chancery, and then you all further agreed to Sigifredo Perez, and then I reviewed his report, and that puts us in a different situation. What about that is incorrect, Ms. Aldana?
It is incorrect that we did not agree. My clients and I did not agree to the master in chancery. In fact, we had a hearing where the court ordered that a master in chancery be appointed and file reports. And so that was not an agreement. The other issue that was not an agreement was Mr. Sigifredo Perez. Because I was objecting to the master in chancery appointment, I did not agree to anyone being appointed. So that was not an agreement. In fact, I filed a response objecting to the master's report, as was allowed in court at that hearing. I was given.
So let's do this. Remind me, Ms. Aldana, when did you make a request for rehearing, or did you send in another fiat for the special appearance and motion to dismiss?
I filed a special appearance order setting hearing a while back, and it was never signed. It was never given a hearing. So I filed a motion to reinstate the special appearance and a separate motion to reinstate the Ms. Naila Guerra's motion to dismiss.
I'm not sure how they would be reinstated if they were never said or heard, but assuming that that is true, and I don't know that it is. But when did you file those motions to reinstate?
I filed it timely. I filed it 3 days before this hearing. The 3 days was Sunday, however.
Well, no, that is factually incorrect. So timely does not mean 3 days before, because the court needs to send out notice at least 3 days. But that doesn't mean that you mail it in or you hit send on the electronic service, because when you do that, it first goes to the clerk's office, then they process, then they send it upstairs electronically to the coordinator, then they process it. It gets reviewed by her and by our staff attorney, and then gets sent to me. That, on a good day, takes 1 to 2 days. So if you file 3 days before, you're already outside the setting window, because things don't happen by osmosis. So let's do this in the interest of fairness and justice. The motion to dismiss is not set for today. The court will not hear that until we can set it notice it, set it, and give counsel time to respond. The special appearance is a different animal because those take precedence over all other motions. So, Mr. Tamez, what objection, if any, do you have to the court hearing a special appearance?
It's been waived.
Tell the court how and why.
Judge, a special appearance, as you know, is a vehicle that's used procedurally by a party who's denying that the court lacks jurisdiction over it. In this particular case, Mr. Guerra has participated in the litigation of the current proceedings before the court. Mr. Guerra, as we've already discussed, and this is just a delay, he lives in Webb County. Right? The property subject to the suit is in Webb County. And he was served with citation and he has answered. All of those are precursors to a clear waiver of any special appearance, but just the fact that he lives in Webb County, was served in Webb County, the property subject to this enforcement action is in Webb County. I just don't see under the rules of procedure how, with a straight face, counsel can come in here and saying that she's entitled to a special appearance for Mr. Guerra. It's beyond me.
And Ms. Alanya, in response, what is your position or argument as to the special appearance and now respond to the waiver argument?
All right, guys, today we are stepping straight into a courtroom where the tone is calm, but the stakes are already brewing beneath the surface. The judge sets the stage, confirming appearances through video conference, and everything feels procedural at first glance. But this quiet opening is deceptive, because it signals a complex case involving multiple parties and legal layers. Even in these first few seconds, you can sense this won't be a routine hearing. The structure is formal, but the tension is quietly building. This is the kind of opening that hints something much bigger is about to unfold.
Yes, Your Honor. My client did not waive his special appearance. In addition to the special appearance, my client also filed within that special appearance. He challenged personal jurisdiction. He challenged in rem jurisdiction. He challenged the plea to the he filed a plea to the jurisdiction within that. He requested the court to decline jurisdiction in addition to his original answer. None of that has been heard. We're asking that it be heard. He did not waive it because he was
Tell the
saying,
court factually and legally how if true, how is that substantiated? Like what, flesh that out for the court.
yes, Your Honor. So my client is saying that the court did not have, or is requesting that the court decline jurisdiction because in the divorce decree and in the divorce, he was never made a party. Yet the property that is under his name, he's the record owner, it was never brought in. And so rulings were made forcing him to, or ordering him to sign a warranty deed for the property when he was never given due process in that divorce. In addition to that, now the master in chancery is saying that, in his opinion, Ms. Naila Guerra and Mr. Salcedo, Rogelio Salcedo, are equitable title owners. However, in order for that, for anyone to come to that conclusion, the title owner must have been included in that original hearing, that divorce hearing, and he wasn't. And I cited in my response all the reasons why, all the statutes that support that he should have been made a party to that case. So because he was not made a party, then I'm asking the court to decline jurisdiction because he wasn't given the due process.
Reply to that response, Mr. Tamis.
He was served. What happened in the
He was served when and where or how? Into the record?
He was served in this proceeding, Judge, for enforcement.
Well, so in response, Mr. Tamis says that he was served here. Let me ask you all this, because I spent some time in the history of this case, and the reason it really now sticks out in my mind is because Mr. Salcedo is moving to enforce a decree that the court signed in May of 2017. Now, that time period is fairly memorable to the court because this court had been on the bench for 1 month. So in what would happen at that juncture, if I recall correctly, based on my memory and reviewing the docket, is that two other lawyers, unless I'm mistaken, two other lawyers announce an agreement between Mr. Salcedo and Ms. Guerra, and the court signed that final decree of divorce by agreement. Now, I read that agreement. I went back, May 2017. And in that final decree of divorce, what that decree says is that Mr. Salcedo and Ms. Guerra are to divide this property equally, being co-owners or the marital property, one half each. Does that sound about right, Ms. Aldana?
Not entirely, because it did not in the divorce decree ever state that that property was community property. In fact, it didn't say that they were owners of the property.
But anything silent is inferred. In other words, you have a duty, Ms. Guerra has a duty, Mr. Tamés has a duty, Ms. Salcedo. Every person before the court has a duty to disclose anything that should be known. So that at the time that the court enters in a division order for one half each, that would have been the best time to tell the court, by the way, there's other persons that own this property.
Yes.
Is that not the case?
You are absolutely correct, Your Honor. That is exactly
So
the
if
time
that's true, and Ms. Guerra would have known, having been a signatory to the final decree of divorce, wouldn't that have been the right time to tell the court, by the way, my father owns a portion of this property?
Yes. And
Was
that
that ever disclosed to the court during that time period?
from the record, no, that I've seen, no. And that's why Mr. Ernesto Guerra was denied his due process. So these
He
two
was
parties,
denied his due process, not because of anything the court did or the other side did, but because of an undisclosed factual piece of relevant information by Ms. Guerra, no?
Texas Code 9.401, lack of jurisdiction. A decree of divorce is void if the court rendering the decree lacked jurisdiction at the time of the decree was rendered. Now, I know that Ms. Naila Guerra.
Say that again. Flesh that out. You cited a point of law. Tell the court how that applies to this case.
Because Mr. Salcedo was not a husband or a wife or any other party to this divorce decree. Mr.
Mr. Salcedo wasn't?
I'm sorry, my client, Mr. Ernesto Guerra. Mr. Ernesto Guerra was not a party to the divorce. So because he was not a party to the divorce, husband and wife can't say we're equitable title owners, but we're going to leave out title.
That is in fact what happened.
That is in fact what happened, and that's exactly why that order is void, at least the order regarding the real property.
Buckle up, guys, because things escalate quickly as multiple motions are placed on the table, instantly raising the complexity of this case. We're not dealing with a single issue here. There are enforcement actions, sanctions, and even property valuation disputes all stacked together. That alone signals conflict from multiple angles. The absence of the Attorney General's participation adds another layer of intrigue, making it clear this case is being fought directly between the parties. From a viewer's perspective, this is where you realize the legal battle is already deep, and every motion carries potential consequences.
Last time I
But
checked,
in order to be void, I guess to the court's point, why didn't someone here, and I would presume that the best person to have that information would be Ms. Guerra. How was that important, relevant, if true, piece of factual information not disclosed to the court, either on the record or made a part of the final decree of divorce? How did that happen?
So it would have been Mr. Salcedo and Ms. Guerra who should have said, we're not the title owners. And the lawyers maybe could have looked up the deed history, to see who is actually on the deed. The problem remains that Texas Rule of Civil Procedure 39, joinder of persons needed for an adjudication. Mr. Guerra should have been included in that conversation. He should have been given notice and due process so that he could defend his title interest, his record interest to that property, which was not community property.
I understand. Anything in response, Mr. Tamés?
Your Honor, last time I checked, Mr. Guerra was not married to Mr. Salcedo, and so it wouldn't void the decree. what counsel is arguing, if true, then her client, where I think she has a very serious conflict between father and daughter. If true, the daughter has committed a fraud to the court because she, under oath, in the proof up of the divorce, agreed that the property would be divided one half between my client and herself. As the court accurately pointed out, that duty to, and she was represented by an attorney. Both parties were. Both parties blessed the divorce decree that was signed by the court. And so if that's the case, if we want to undo everything that the court has already done about 10 years ago, then Ms. Saldaña's client has committed and perpetrated a knowing fraud. Notwithstanding, to address the issue of this mysterious special appearance, Judge, the court's own document shows that the client was served
Inaudible.
For the record.
I believe it's on March 2025. So the Mr. Guerra is before the court. He is a resident of Webb County, and we're here to address these issues because the divorce decree, up to now, my client hasn't received any interest pursuant to the decree. He hasn't received any of the information that decree orders that he be provided. He has not seen any proceeds from any rental. He has just barely, through a lot of struggle, started to receive some of the statements relevant to this property. So to say that, let's parse this out, the special appearance, he is here. He has been served. He is before the court. And he is a resident of this county. So I don't know how a special appearance rectifies that fact.
Like I said, it wasn't just a special appearance, but in addition to that, if Miss Naila Guerra is guilty of fraud, then so is Mr. Saucedo, because he was here and he should have known the history, what the condition of the property he claimed was his.
Well, he did. And
So
he,
if Mrs. Guerra is guilty of it,
Let me ask some questions. And if I missed a pleading, Ms. Aldana or Mr. Tames, you need to remind me. But Ms. Aldana, let's assume that I agree with you in the first instance as to service or notice in the divorce decree. And I don't know that we get there because that is finalized. But there is no question that Mr. Guerra has been served now, and at least since March 2025. Let's assume that the court would grant, and I don't know why it would, but let's assume that the court would grant a special appearance and the dismissal of this claim. Is there any pleading or prayer for relief that would undo the final decree of divorce of May 2017?
All right, guys. Now the real friction begins as the defense pushes back against what was previously assumed to be an agreement. This moment is critical because it challenges the entire foundation of prior proceedings. What seemed settled is suddenly being questioned, and that shakes the case at its core. The claim that there was never any true agreement introduces doubt and opens the door for deeper legal complications. This isn't just disagreement, it's a direct contradiction of the case history. And when that happens in court, everything becomes unstable, and the tension noticeably rises.
Miss Naila Guerra's motion to dismiss for lack of jurisdiction. And
that dismisses this claim, but it does not undo the final decree of divorce.
So if I may
So one more time, is there any procedural vehicle, request for relief, or pleading that either clarifies, undoes, or asks for something that modifies the final decree of divorce?
Yes, Your Honor.
Tell the court what that is.
That is specifically modifying only about Mr. Ernesto Guerra and anything in connection to the real property, not the entire.
What is the pleading and what is the procedural vehicle?
Again, I know that you responded something about Ms. Naila Guerra's, but in Ms. Naila Guerra's motion to dismiss, we're also alleging that there's no jurisdiction because of the lack of due process. So
let's assume that's right, and I don't know that it is. Here's the question that the court has. Let's assume you're right. You win. there's a valid and enforceable final decree of divorce that says the parties need to dispose of this property in this manner. Is there anything in the record that has been pled for relief or any cause of action that modifies, undoes, or rehears or clarifies the final decree of divorce?
Yes, Your Honor.
Tell the court what that is.
And that is, I repeatedly filed documents about that. It was Mr. Guerra's special appearance, his personal personal jurisdiction and in rem jurisdiction, the plea to the jurisdiction, the request for the court to decline jurisdiction. I also added it in the motion, the respondent's response to an objection to the report of Master Chancery, where I cite the Texas Rule of Civil Procedure 39, the joinder of persons needed to be adjudicated, the Texas Constitution, which I cited in my special appearance in rem jurisdiction and in the motion to dismiss, that no citizen of the state shall be deprived of their property in any manner without the due course of law in the land. There's the Texas Rule of Civil Procedure, Rule 124, no judgment without service. In no case shall judgment be rendered against any defendant unless upon service or acceptance or waiver of process. He was ordered by the court, by the divorce decree, to sign a special warranty deed because clearly Mr. Saucedo and Ms. Guerra did not have ownership. In fact, it was not fraud because it was this close, and that's exactly why Mr. Guerra was ordered to sign that special warranty deed. Additionally, I also wrote in here that I filed with the court the Texas Family Code 9.401, lack of jurisdiction, a decree of divorce again, is void if the court rendering decree lacked the jurisdiction at the time. I'm not saying the entire divorce decree is void. All I'm referring to is Ernesto Guerra's portion of it, which is the real property and his person.
Court hereby takes judicial notice of the entire case file. The court makes the following findings at this juncture. The court finds that there is no pleading or request for relief that clarifies, modifies, or changes a valid and enforceable final decree of divorce. 1. 2. The court thereby finds that the service effectuated on March of 2025 makes the special appearance moot. And therefore, for all of these reasons, the remaining motions to dismiss and so forth are hereby respectfully denied. Let's move on to the enforcement, compel, sanctions, and the appointment of a real property appraiser. Ostensibly, Mr. Tames and Ms. Aldana, ostensibly there isn't an agreement, is there?
Well, Your Honor, we were set for mediation. I don't know if that's still something that we were going to do or not. I don't know.
No, Your Honor, I'm ready to go on my motions. And just for the clarification of the court's ruling, I spoke earlier. Ernesto Guerra was served on July 29th, 2025, and the return of service is dated July 30th of 2025. My apologies.
So noted on the record that the date itself doesn't change the findings of the court. There is a valid and enforceable final decree of divorce, and there is no, in plain English, there's no card on the table that allows the court to modify that decree in any form. It's valid and enforceable, and there you go. And then on the subsequent enforcement action, there's service, so on we go. Folks, this is now the third contested matter on the court's docket. Talk to each other, see if you can come to a good place. Anything that you don't agree to, I will make a decision for you.
Yes, Judge, as to the two motions pending before the court today, on the motion.
Well, there are three.
Sorry,
There are three.
I have two.
Motion for enforcement, motion to compel, and appointment of an appraiser.
For the
Motion to compel,
enforcement, we're going to go to mediation. We're going to go to mediation for that.
Well, I don't know what the motion for enforcement means, but I have two: motion to compel and motion to have the court appoint appraiser.
The motion for enforcement of property division and modification of the child support order was filed by,
Well, that's me, but I think that's on the merits. I don't know why that's
oh, they're not, well, no, there's a petition and then there's a separate motion.
really.
You said on both.
Okay, well, I think the motion itself, Judge, is for purpose of the petition on the merits, which that's still pending based on
Sure,
protracted discovery issues that we're having in this case.
sure.
Before we continue, Your Honor, there is background noise from Ms. Guerra.
It's good. We're gonna put you on mute momentarily because we want to make sure we have a. There it is. All right. All right. I apologize. Go ahead.
No, Your Honor. My apologies if that, for some reason, that was confusing on my part. I'm not sure what that motion was, but on the motion to compel, Judge, this was a discovery that was propounded on Mr. Guerra, and we never received any responses. Council has agreed that the objections have been overruled. Serve a discovery responses within 2 weeks.
Buckle up, because the judge steps in firmly here, and this is where authority takes center stage. The attempt to justify a last-minute filing gets completely dismantled, with the judge explaining in detail why timely doesn't mean what the defense claims it does. This isn't just a correction, it's a shutdown. The courtroom dynamic shifts instantly, as the judge reinforces procedure and control. You can feel the frustration beneath the professionalism, and it sends a clear message: shortcuts won't work here. Moments like this remind everyone that courtroom rules are not flexible, and missteps carry consequences.
The motion to appoint the appraiser, Your Honor, that is based on the report that the Master in Chancery, Mr. Sigifredo Perez, filed with the court. And so for purposes of effectuating that report from the Master in Chancery, the parties have agreed that they will name Paul Porras to conduct an appraisal of the property at issue, that being the apartment. And then we can file an advisory with the court with that appraisal. I don't think we discussed this with Ms. Saldana, but I would propose that Mr. Porras's costs be divided equally amongst the three parties, 1/3 each.
Ms. Alanya?
I am requesting that if it's gonna be divided, that at the very least it be Mr. Salcedo and Ms. Guerra 50-50.
And the only reason I say that is because, as we heard prior, Mr. Guerra continues to say that he owns the property. So I think it's only fair that the parties split that 1/3 each. We've got a person claiming legal title and two people that have claimed equitable title pursuant to the court's decree. So I say we split it 1/3 each.
Yikes! What a difficult call you all set up for the courts. So on the one hand, because normally what I would say is everybody get 50-50. You have two sides. Ms. Saldana says special appearance. This person isn't here. He owns it but shouldn't pay. And that seems like an inconsistency. Well, I've overruled the special appearance. If there is an agreement, let me think about this. If there is an agreement that the thing be appraised is the true, right, and just and equitable thing to do, to be divided half or 1/3, Mr. Tamez argues that he is a proper party and has been served. Ms. Alanya says it's his property, but isn't really here. If it is his property, why wouldn't he be subject to pay equally with everyone unless he isn't an owner and then he had nothing to do with this? You see the inconsistency. I mean, it's like he wants both things. He wants to be an owner, but not have anything to do with the allocation of this court's ruling at the end of the day. I mean, it would have been a lot easier had the reverse been true. Had Mr. Tamez said there's two sides, 50-50, And Ms. Alania said, no, he's an owner. We disagree with the court's ruling, but he's an owner, so he gets to chime in. But now she's saying he's an owner, but he's absolved of any payment on this. What an interesting situation. Yeah, I mean, crystallize your arguments, Mr. Tamez. Why should Mr. Guerra pay? And I'm going to ask you the reverse, Ms. Alenia. Crystallize this, please, because I see that there's just some logical inconsistencies with saying you didn't serve me. I'm not really here. It's my property. I'm not paying to have my property evaluated. Give me why should Mr. Guerra pay Mr. Tamez?
Yeah, so as I mentioned before, Judge, the law recognizes title, right? Title ownership is an incidence of ownership. The court and our legal system in Texas also recognizes equitable title. Now, from what I've heard from counsel in representing Mr. Guerra, she's saying, I don't care if the court adjudicated equitable title in Mr. Saucedo and Ms. Neyla Guerra. The owner is Mr. Guerra. Okay. That's going to be litigated. That's going to be determined to what extent. But because of that, the law recognizes bare legal title and equitable ownership. In this case, I'm assuming we have three parties. We have one plaintiff, two defendants. They're all making claims of ownership, equitable ownership as to Mr. Saucedo, equitable ownership as to Ms. Guerra, and bare legal title for Mr. Guerra. So I think equally all three should be burdened with this cost because that's the argument they're making.
Response: why should Mr. Guerra not take a 1/3 of this bill, Ms. Alania?
This is an enforcement of a divorce decree, a divorce between husband and wife. They're the ones that Mr. Saucedo is seeking some remedy from Ms. Neyla Guerra. As far as any arguments about title, that should have been done in 2017. And therefore, our position remains that Mr. Guerra was not made a party. And therefore, to say we have equitable title just because we said so is inappropriate because the true record owner was never brought in. And now, not only was he denied due process back then, now he's being told, in addition to that, now you have to pay 1/3 of this appraisal.
All right, guys, now we enter a direct legal clash where both sides are digging in on jurisdiction. The opposing counsel lays out a straightforward argument. Residency, service, and property location all point to clear authority of the court. It's presented almost as undeniable, which makes the defense's position look increasingly strained. This is where logic and legal structure collide with strategy. The tone sharpens, and the argument becomes less about theory and more about facts on record. It's a pivotal moment where one side tries to close the door completely on the other's claim.
It's unjust.
Let me ask you this. Let me ask you both this, and I don't know the answer. And the answer to these questions is going to resolve this issue. Although it's a 1/3, I can't imagine that this is. I don't think anybody should be losing sleep over this. But I do want to get it right in any event. So, what in the record, Mr. Tamez? And I'm going to ask you the same question. Right? Maybe I'll start in reverse this time, Ms. Alania, and then I'm going to ask you, Mr. Tamez. Ms. Alania, what in the record reflects that Mr. Guerra is an owner, whether in title or in equity or anything else? Because what the court presumes at this juncture is that the only finding is in the final decree of divorce, May of 2017, that says there's two owners. So just on that, just at that one time one, there's two people, there should be two split 50-50. But I think your client, Mr. Guerra, is now making the argument that he's some sort of owner. If that's true, then he should partake in this fee. So tell the court what in the court's record, in the case file, evidences shows and proves that Mr. Guerra is a title owner, either in fact, in equity, or anything else.
The final divorce decree orders him to sign a special warranty deed because they recognized that he is the title owner. Again and again, we have filed a deed showing that he is the title owner. Again and again, we filed pleadings showing that he is the title owner and that he was never given due process to defend his title.
Same question, Mr. Temes?
Yes, Judge. I think what counsel misses is that there's two types of ownership. And bare legal title does not mean that my client or the court could not adjudicate that they have equitable title. I understand this argument. I think that's been discussed ad nauseum. The gentleman is before the court. The gentleman is here, and I assume the gentleman is continue to argue that it's his property. So if the gentleman is going to continue to make that argument, that I think the gentleman needs to be proportionally charged with the expenses of defending this bare legal title that he's claiming. I think that's equitable. If not, then that's fine. We'll split it 50-50, but I think that will cut against this argument because you can't have that duality. You can't make at one time an argument that I am the owner at the same time saying, but I'm not going to take any responsibility and pay no expenses as a true owner. So it's inconsistent and it's, we can't have it both ways. But, you're right, Judge. At the end of the day, I think Mr. Porras charges $750. It's not going to break anybody's bank. We'll live with whatever order the court decides. But this is just another example of how we're having these inconsistent claims being brought before the court. And I'll stop there.
It's never been inconsistent. I've always advised the court that Mr. Guerra was never given due process. I've never been inconsistent about that.
The inconsistency is in the failure to recognize title, bare legal title, and equitable title. As the law is recognized in the state of Texas and has long been recognized in the state of Texas, that exists. Ignoring it does not make her position correct.
Well, they ignored the due process. They ignored joining Mr. Guerra as a party to defend his title record to people who are claiming equitable title. He was supposed to be joined, and he wasn't.
It's the language that I'm mulling over. So under petitioner 7, the portion of the decree that awards the house, both parties affirm, and they acknowledge on page 31, they acknowledge that they've had time to review, they acknowledge receipt of the decree, they acknowledge they were represented. So everybody knew what they were getting into, and nobody can take that back. Not Mr. Saucedo, not Ms. Guerra. But then on petitioner 7, the line item that designates the house, it clearly says that these two parties own a 1/2 interest. Doesn't mention anybody else. Now, that has to be tempered with the portion on page 30 that says, but there's going to be a special warranty deed between the parties. And then on page 29, it does. Now I see Ms. Aldana's point. On page 29, it mentions Mr. Ernesto Guerra. So what's clear to the court is that the parties, and in this case particularly, Ms. Guerra, contemplated this and entered into this agreement being fully advised, but haven't been given an opportunity to read, review, and object to if it was an incorrect decision. But there is also nothing in the record that allows the court to crack that egg open. In other words, I can't undo that. I see the inconsistency, but there is nothing in the record that allows this court to go out and change that. So this is the result. The only two parties that were party to that decree are Mr. Saucedo and Ms. Guerra. So the cost is split 1/2 each, but it's clear to me that Mr. Guerra has a claim against Ms. Guerra for that representation, whether it was truthful or not.
Buckle up, because the defense shifts gears and introduces a powerful angle: due process. This is where the stakes suddenly feel much higher. The claim that someone's property rights were affected without them even being part of the original case is serious. It's not just a procedural issue anymore, it's about fairness and legal rights. This argument reframes the entire situation and forces the court to consider whether something fundamental was overlooked. When due process enters the conversation, it adds weight, urgency, and a sense that the outcome could have broader implications.
That's where it stands.
I'm curious,
Um,
why isn't Mr. Salcedo involved if he made that same allegation? Why is it only Ms. Guerra that's being pointed out?
I would answer that question by the fact that they're sitting right next to each other, Judge. It's father and daughter. I mean,
That is not sufficient.
you know,
Mr.
if
think
if
that
the
is sufficient, yeah.
question, Ms. Saldana, is whether each party had a legal duty to disclose, I think the answer is yes. I think Mr. Salcedo had a legal duty and Ms. Guerra had a legal duty. If the question is who had the moral obligation to advise the parent that they were being brought into the suit in this manner, I think the answer is clear too. But as a matter of law, I think you're right, Ms. Saldana. As a matter of law, you are right.
As a matter of law, it is a void order to order him to
All
sign.
right, already ruled. Those are the orders of the court. We will see you here. You said that there was an agreement to mediate. Did the court hear that?
I think that's not accurate at all. We had an agreement to mediate back in January, and the agreement that I had with Ms. Saldana was you produce the documents that I'm sending you in discovery because I need that information to make a fully apprised and acknowledged recommendation to my client at mediation. The path that has been chosen by the respondents is to obfuscate discovery, as you can see by today, and as you can see by the fact that I had to file a motion for contempt with a show cause order.
So knowing all of this,
Yeah.
knowing that there's now an agreement as to the responses and now the appraisal, and now the court even sided with Ms. Alania as to the disposition, the payment and division of that bill, how much time would be reasonable? And I think, are you going back to the master or not?
I don't think so, Your Honor, unless if we need to take depositions to further discover some items, we
All
can
right.
possibly do that. But for now, I think it's getting the appraisal. I have a motion to for contempt.
Knowing the but I thought there was an agreement on that,
On the what?
on the motion for contempt.
No, that's just on the motion to compel. Separately, I just filed last night a motion for contempt with the show cause order on Ms. Neila Guerra, because aside from the fact that we already had to file a motion to compel discovery responsible for her, I still have not gotten the discovery responses. And so I was forced to file a motion for contempt on Ms. Neila Guerra. Today was just a motion to compel Mr. Guerra.
Well, so knowing all of these things, Ms. Alenia, knowing that there's an agreement as to the responses and no objection, the objections being waived and the 2 weeks, and now Mr. Porras is coming in to do the appraisal, what type of scheduling order, how much time would be reasonable and necessary to schedule, I guess, the contempt, which ostensibly could be moved if this thing is resolved, and then a final hearing, Ms. Alenia?
I would ask for 45 to 60 days because I did give Mr. Tamez all the documents that Ms. Guerra was able to give to me. He's asking for more detailed information. So in order to be able to go back through the years to try to get that, then we're going to need some more time.
Ms. Alenia says 45 to 60 days is reasonable and necessary. Your response, Mr. Tamez?
For a trial on merits, 60 would be the minimum based on the way this thing is being discovered and litigated.
A minimum. So there is no objection to that. Now, regarding scheduling, if you're asking for a final setting in 60 days, and that was the max that Ms. Alania was asking for, are you asking for a separate setting on the show cause?
Yes.
How much time would be reasonable and necessary for that hearing?
Just to, how much, as far as
2 weeks, 4 weeks, 6 weeks?
Minimum a week, Judge, 2 weeks, so I can get Ms. Neila Guerra served with precept.
So,
If her responses are due in 2 weeks, does what procedurally or factually would one have to come before the other?
No, so the responses that we've agreed to serve in 2 weeks is the ones on the discovery on Mr. Guerra. Motion for contempt is on Ms. Neila Guerra. And I have plenty of reasons why in that motion to contempt that it's not just as easy as saying, oh, she gave me everything she has. But a lot of time has been spent on this, Judge, unnecessarily. But this is the path that the respondents have chosen. And so I
Mr. Tamez says 2 weeks on the show cause. Your response, Ms. Alania?
I agree. The order with the real property is void. So yes, a lot of time has been spent on this.
I've ruled, and I appreciate the argument. I think it was a good argument. I've already ruled. I understand, Miss Aldana. I understand your position. It just doesn't help to hear the same argument when I've already ruled. And my question is, for Mr. Tames's request, unless you tell me that 2 weeks is not reasonable, I'm going to set that. Please answer that question.
I was asking for 45 to 60 days for Nyla's contempt so that we can try to get the information that he's asking for, because he's asking for years from before.
That's the
So
answer that I needed
That was what
to
I was
hear.
asking.
All right. We'll come back on the show cause on May 19th at
I'm out of town that day. I have a vacation. This time I do know that I have a vacation letter.
yes, it starts on the 18th. It's been calendared. Come back on May the 5th at 1:30. Any objection, Ms. Alania?
Yes, Your Honor, that is not sufficient time to get all of the information.
Your Honor, if I could just, so the discovery responses were due back in January. So I don't know how much more time counsel needs after I've already filed a motion to compel, had to come to court, get an agreed order. And I still don't have the responsive documents. And we're now in April. So conceivably, Ms. Nayla Guerra has had 6 months, half a year to compile the documents that have been requested, which are in her possession, custody, or control, and answer each one of those interrogatories fully. I just don't know why it would take that much time, Judge. Under the rules give us 30 days.
Whatever is in her possession, custody, and control is what she handed over to Mr. Thomas's client. So she didn't do anything wrong. She didn't hide anything. She gave what was in her possession, custody, and control. If he wants more, then we're asking for time so we can try to get more. You know, maybe I would like to confer with him and see exactly what he's asking for, because I gave him what she gave me, what
All
she
right. We'll come back on the show cause order on May the 5th at 1:30. We'll come back for final hearing on June the 18th at 9 a.m. Anything else on this case, Mr. Tames?
No, Your Honor.
Ms. Alania?
No, Your Honor.
Do you have any questions for the court, Mr. Salcedo? Court has heard no. Ms. Guerra, do you have any questions for the court? Court has seen no. Mr. Guerra, do you have any questions for the court? I didn't hear that. Can you? Yes.
No.
Thank you, Mr. Guerra. Miss Alania?
Yes, Your Honor. June 18th at 2 p.m.
Excuse me, June the 18th at 9 a.m.
9. Thank you.
Mr. Saucedo, Ms. Guerra, a lot of moving parts, a lot of first-time issues that haven't been contemplated, certainly not in this specific type of scenario. So keep in contact with your lawyers. They're going to continue providing you some good legal advice and preparing you for your hearings. Mr. Saucedo, Ms. Guerra, and Mr. Guerra, I wish you all very well. Have a good day.
Thank you, Your Honor.
All right, guys, this is where everything peaks as accusations of fraud enter the picture, and the courtroom tension hits its highest point. The argument shifts from technicalities to serious allegations, suggesting that key information may have been deliberately hidden. That alone changes the tone completely. But what makes this moment even stronger is the judge's response, cutting through the noise and asking the ultimate question: even if you win, what actually changes? It's a powerful reality check that corners both sides, exposing the gap between argument and outcome, and leaving the entire case hanging on that critical point.